Former President Trump's fate is in the hands of 12 regular people, the jury. Should they be sequestered?
I would say yes.
There's no way to get away from all of the input. If you're not in the courtroom a lot, that it can be a very imposing sort of thing. It can be very imposing to witnesses and to jurors. Do you think he will testify?
He's saying he will.
As a prosecutor, would you want him to testify?
Absolutely.
Well, this was day 7 of the Trump trial. Last night, we began a deep dive into what is being called the trial of the century, the people of the state of New York versus Donald Trump. In reality, it is a big, big case. I'm not saying that it involves important legal matters. I'm not saying that it has some profound effect on America in terms of what is alleged. But I'm saying the fact that a former president and current Republican nominee facing a criminal trial and up to 4 years in jail if convicted is a big deal in the history of this country. If given jail time, the ramifications are unprecedented. A president in prison. What does that say on the international stage? Tonight, we're continuing our conversation, a conversation no one is having right now. Former President Trump's fate is in the hands of 12 regular people, the jury. It includes 2 lawyers, and they will be the ones problem-solving this case. But how were they chosen for this monumental and historical task? Who are they, and how does each one of them individually impact this case? How do they impact it collectively? How are they forming their relationships inside that jury box? And how will they sit down and solve this puzzle? Well, it's been busy so far going through all of this, right? And
yes.
Lonnie, thank you so much for coming back again to talk about this some more. Your input and expertise has been invaluable. 12 people in a box, 7 men, 5 women that are going to make a decision in what could be one of the most landmark cases in the history of the United States. Now, these 12 people are in such a high-pressure situation here, and I've said before, with proper research, with proper understanding, you can deliver to them what they need. You can figure out what they need. And that's what we want to do. It's not a matter of trying to manipulate the truth, trying to spin things. It's a matter of saying, out of all this universe of facts, they need to know certain things to make an informed decision to get to justice. Politics aside, personalities aside, what do they need to make the right decision? And one of the things everybody's going to be curious about is, should Donald Trump testify? Do they need to hear him testify? They've certainly heard a lot from him already, right, because he's so in the news, he's so prolific in our society. Do you think, as a prosecutor, would you want him to testify?
Absolutely. 100% I would love for him to testify, because the prosecutors have asked the judge, if he takes the stand, can we ask him about all of these other prior acts? And the judge has said yes to a number of them. So if he takes the stand, that cross-examination would be brutal. It would be very hard on him. It
would be far-reaching, right?
Yes.
What has the judge said they can get into in front of the jury?
So he can talk about the E.G. Carroll case, also part of the civil fraud case, and also violations of gag orders that he has had in other cases. So really what they're supposed to focus on is things that go to his truthfulness and his credibility, not other things like prior sexual allegations or anything like that. That's not really what's relevant. What's relevant is his credibility and truthfulness as a witness, and that's what they can really attack in these prior acts information.
From a defense side, what do you think they should be worried about?
The problem for any defendant who takes a stand is, once they get up there, the jury kind of forgets everything else that the prosecution has done. They take the burden off the prosecution and they put it on the defendant, and they say, we're going to judge you. If we don't believe you, we're going to find you guilty. If we do believe you, we might not. instead of looking at the evidence, right? It really shouldn't rise or fall on his own testimony. It should rise and fall on if the evidence is there first, because it's the prosecution's burden. But once the defendant takes a stand, the jury really focuses on them and really kind of puts their whole decision on the credibility there.
But one of the things I would be concerned about from a defense side, if I'm looking at this through the jury's eyes, is he doesn't have an edit button. I mean, we know that he gets up and gets on a roll. And I know if I was doing witness prep with this individual, I would want to spend a lot of time with him, teaching him the rules of testifying. And it doesn't mean that he's not smart, doesn't mean that he doesn't know what he knows and have the truth that he wants to convey. But I don't think he has an edit button. And if he gets up there and starts the hyperbole that he tends to get into, and oh, this is the greatest thing and this is that, under oath, that's not hyperbole. That's a statement of truth that if it's not true, you can be subject to the penalties of perjury. And I think now he could create a whole new cause of action in trying to persuade the jury. And I'm not sure that he's great at reading the room sometimes. So he might think, yeah, everybody's going along with me here. And he gets on a roll and starts saying some things that I think could get him in trouble on the witness stand.
That's a great point, because he will be under oath.
Do you think he will testify?
He's saying he will. He's saying he will. And, you know, he's used to making his own decisions, right? He was the president of the United States. I think sometimes about how, you know, when he was president, he would walk in and everyone would stand. And when he left, everyone would leave. In the courtroom, it's the judge doing that. And it's got to be a very surreal experience for him to not have that position. So I think he says he's doing it. And I think that he will make that decision. I think his attorneys will be trying very, very hard to persuade him not to.
Well, we'll know who's running the trial team if he testifies or if he doesn't. Because if the lawyers are running the trial team, if there is a jury specialist working with this trial team, he will not take the witness stand. I don't think that's a close call at all. If he's running the trial team, if he's giving orders, then maybe he will take the stand. But no objective party involved in this that's making decisions would put him on the witness stand. I don't think that's even a close call.
I agree.
And then the question becomes, does the jury need to hear him in order to problem solve this case and get to a decision? And frankly, I don't think they need to. I don't think they need to hear him say that he didn't have knowledge of this or he didn't do A, B, or C in order to problem solve this case.
I agree. I mean, the defense says, look, he wasn't involved in any of this. And actually not taking the stand kind of keeps that distance from it. Like, I have no information about this, so decide it over here. And he has really good defense attorneys who will make those arguments in a really good way.
Yeah. Now, one of the things that this boils down to, that the jury has to sit back and say, okay, I have to make a decision about what is going to be asked of me about where lines are and if they were crossed. And it has to do with him doing certain things to influence an election. And we're going to talk about that before we're done tonight. And I think it's what this case is going to turn on in the jury's mind. I want to talk a little bit about how we've gotten to where we are, how President Trump has gotten into the courtroom. And we've devised a timeline to kind of put this visually in front of people. Can we step up and go take a look at that?
Absolutely.
President Trump announces that he's running for president June 16th. And this is just important because they say after this, anything that they're questioning would be for election influence or interference, depending on what you say. So once he says he's running, then they start looking at what he's done. Then in August the 15th, there's a meeting between his attorney, Michael Cohen, Mr. Pecker, who is head of AMI, that owns National Enquirer, and Trump himself. And they devise what they call a catch and kill, which is they're going to help by saying if we get wind of any negative stories out there, we're going to try to get a hold of those. We'll pay for them, we'll buy them, get exclusive rights to them, but not publish them.
Right. So it kills the story.
And they call it catch and kill.
Which is a common thing done.
Right. Okay, that's in August of 2015. June of 16, Karen McDougal claims that she's had an affair with Trump, and they get wind of that, right? And so then AMI and Cohen, they do a catch and kill, and there's $150,000 paid to her a few months later in September. It's mentioned in the pleadings on the current case, but President Trump or Cohen don't ever pay anything. AMI pays for it, and then they just decide to eat that. They're never reimbursed for it. So there are no entries for it, nothing ever happens, and it never goes anywhere.
But it is going to be part of the trial. The prosecution's going to put it in because they say that this is part of a pattern.
Right.
Right.
But there are no bookkeeping entries, nothing. And then here, October 10th, 2016, Stormy Daniels, as she's known,
right,
that's her stage name, claims that she had a sexual encounter with Trump on October 10th, 2016. Now, Cohen and Daniels' attorney make a deal, $130,000
right,
to be paid. Now, a big question, and this could wind up in the jury charge, where the jury is asked whether or not Cohen paying this money for an NDA of $130,000 amounts to a contribution to the campaign.
Yeah, I think the way the prosecution's going to lay it out is hush money paid, not a crime. But if they falsify the documents regarding it, say it's something else, with the intent to commit another crime, in other words, cover up another crime, then it becomes a felony. So they'll be looking at, did they falsify the documents? And were they doing it to commit that second crime, which right now we think it has something to do with election interference. We're not really sure what that second crime is, but that's what the prosecution theory is.
But they could be asked a question, did this amount to a campaign contribution?
The secondary crime they're looking at, the intent to cover that up, it could be election interference, it could be a tax violation, it could be a campaign violation. There's a number of different crimes.
Well, Trump wins the election, November 8th, 2016.
Prosecutors allege the payment to Stormy Daniels was part of a catch-and-kill scheme Trump devised with longtime friend and then National Enquirer publisher David Pecker.
Catch and kill, that is, pay someone and then kill a story that would be damaging to Donald.
I am ashamed that I chose to take part in concealing Mr. Trump's illicit acts rather than listening to my own conscience.
So in January of 17, he's now the president, Trump, CFO Weisselberg, and Cohen agree to pay Cohen $420,000. It's in the form of 12 payments of $35,000 and $130,000 for Daniels, and that was doubled because he had to pay taxes on it, and then $50,000 for technical services, and then a $60,000 a year in bonus. That adds up to the $420,000.
Right.
Now, the question is, were these payments here 12 months of $35,000 for a retainer, legal services, was that okay or was it not?
Michael Cohen says this is a reimbursement for the payment that I made personally to Stormy Daniels for the $130,000 that we agreed upon. And this is the way that I was getting paid back.
Yeah. And towards that end, in February, he submits invoices to the Trump Organization. And this is where it says that there weren't really
Right.
a need for those invoices because it was for something else.
Yeah, he says it was legal services.
Right. Okay. Now, then August 21, Cohen says that he arranged hush money payments for Trump and an investigation starts. All right, he was facing 65 years. 60 years had to do with IRS problems. 5 years had to do with problems associated with Trump. He pled the whole thing down to just 3 years in exchange for telling them that a $130,000 payment was made for the purpose of influencing the election. So, of course, the Trump camp will say he had a lot of incentive to do that.
Right.
Right? He went from 65 years that he was facing for 2 counts down to 3 years in exchange for telling them what they wanted to hear about that payment.
And this was where Michael Cohen turned, because remember, he was Donald Trump's right-hand man for a long time. I mean, they were very close. They worked closely together for many years. And then this is where that flips.
Right. You jump over 5 years, and Trump is indicted by the grand jury.
Right.
Took them a long time to get there.
And that time frame is interesting because it did take the prosecution a long time to finally file the indictment, but because it was 5 years, it couldn't just be a misdemeanor, right? Because the misdemeanor has a statute of limitations of 2 years. So for them to be able to file any charges, they had to be a felony charge. And that's how they say they go from the second degree falsifying documents to adding in a second crime that they needed to intend to try and cover up, so you get it up to a felony. Otherwise, they wouldn't have been able to file the charges.
All right. And the question is, from a jury standpoint, is how are they going to problem solve this, and is this going to make sense to them? And are they going to believe that it's a reasonable deduction to come up with this sort of indictment against President Trump, or is there some other motivation for this? I mean, that's their whole thing. So, should President Trump take the stand? He says he's going to. 12 people sit in a jury box. At the end of the day, they're going home. There's a big question, should they go home or should they be sequestered?